So, hello everyone, and welcome again to Criminal Law 2, looking at substantive criminal law. So, up until this point, we have covered elements of crime, like what constitutes a crime, maybe the actus reus, the mens rea, that sort of thing. Last class, we looked at justification defenses to criminal liability. Right? Remember, justification defense is where you say, yes, I committed the crime, but under the circumstances, it wasn't wrong. Right? So this is where we have self-defense, right? Where you're like, yes, I killed the person, but under the circumstances, because they were about to kill me, it's not wrong. Same thing with choice of evils defense. Right, we discussed things like the castle doctrine. We discussed stand your ground. Really anything that says basically, yes, I did it, but under the circumstances, it should be, it's not, it should not be punished, should not be considered criminal. So today, we are moving into not justification defenses, which we just finished, but we're looking at excuse defenses. Right, so recall that whenever you see a potential case or a potential issue, whether it's on an exam or whether it's in real life, you're going to begin by asking yourself three questions. Right, first question is, was there a crime committed here? So you're going to walk through the actus reus, the mens rea, noting if it's required, if it's intent, attendant circumstances, causation, harm, all that jazz. You're going to walk through that. And if you say, yes, there is a crime, then you move to step two. You say, okay, is this crime justified? Right? Is there some kind of justification for this crime? And you'll go through those steps as well. And if you say no to the first one, that there's no crime, still do the second question and the third question, just to save yourself. So you're going to say, is it justified? Yes or no. If we say it's not justified, then we move down and we ask the final question of, is there an excuse to this criminal liability? Right, so first question is there a crime? Second question, is it justified? Third question, is it excused? Right? And this is actually what prosecutors really a lot of times do. Is they may get a potential case, look at it, they'll do an analysis, and they'll say, okay, well, it looks like this crime was committed, and the evidence of this crime looks like it committed. Oh, but there's a justification here. And they might choose not to bring charges just so they don't have a loss on their record, and because if it's justified or excused, a lot of times there's no reason to drag somebody through the process. Now, excuse is a little bit different. There are some excuse defenses where you should be dragged through the process because we need to address what caused the situation in kind of a judicially enforced manner. So let's jump in. All right, so excuse defenses, again, this is just kind of a review. Same thing is true for justification. So you present an excuse defense after the prosecution has proved its case beyond a reasonable doubt, and the defendant's conduct was not justified. Right? So the three analytical steps. Was there criminal conduct? If yes, was the conduct justified? If no, is the conduct excused? And what we are going to look at today is we are going to look at insanity, diminished capacity, age, duress, intoxication, and entrapment. These are all excuse defenses, right? Where you say, yes, I committed the crime, and what I did was wrong under the circumstances, but also under the circumstances, I could not control my actions. Right? That's where excuse comes into play. Is you're saying, whereas justification, you're saying, yes, it was a crime technically, but it was right to do. Here you're saying, yes, it was a crime, it was wrong to do, but under the circumstances, I should not be held responsible because I could not control my actions fully. Now, one thing that we will not talk about, but it's worth noting, is this is also true for, and it is included in justification defenses, are syndromes. And so things like PMS and PTSD, as of right now, are generally not recognized in court, which is, I would hope, would change soon. Especially we're talking like people who have severe PTSD. Or think about people who've come back from the wars overseas, and this happens a lot. They wake up maybe in the middle of the night and they think that they're there. They think that their partner who's in bed with them or whatever is trying to hurt them, and so they kill them, or something along those lines. That they literally just kind of snapped out of it. And their reality is, I'm at war, until they can get back into that, to actual reality. Right now, we don't allow that. So PTSD is not a defense. You could plead insanity or temporary insanity, right? And we're going to talk about all the different tests for insanity that there are. There's a bunch. So that's always an option, but again, syndromes, so far, not a defense. So let's begin with the insanity defense. So insanity and competency are two different things, right? So competency is not a defense. What competency requires is two things. One, that you are mentally capable of understanding the legal proceedings. And two, you can consult with a lawyer in a meaningful way in aid of your defense. All right, so what happens here is, let's say that we come across somebody who maybe, and again, this is a legal term, and it's, I mean, the proper term is like developmental disabilities, but in the law, we still use the term mental retardation. The law just doesn't catch up with the rest of the world. It just is what it is. So maybe somebody has developmental disabilities. Maybe somebody is legitimately severely mentally ill and is being treated or not being treated, and they just wouldn't understand what's happening. Right? You have to understand what's happening to you. You have to understand and be able to talk to your lawyer and help and aid your own defense. Right? Your lawyer can't do it all. Your lawyer wasn't there, but you were. So what we do with competency is, if we say that somebody is incompetent to stand trial, what this means is we basically do what we do with insanity, is we send them to a facility to get treated, get right medication, whatever it is, until the point that they can stand trial, that they do understand what's going on, and they can talk to their lawyer. Once we get to that point, then we hold the trial. Right? The statute of limitations gets suspended when we have competency, because the case is already brought. We're just waiting for this person to be able to get to the point mentally where they can understand what's happening. Now, that should not be confused with insanity. Insanity is a defense, right? Competency is not a defense. It's just we're waiting until you're competent to stand trial. And competency also actually comes into play in sentencing. Supreme Court in the past year has come down with some surprising rulings, ones that I did not expect whatsoever, even coming from the conservative block of the court. So there was a man in Texas, go figure, who was on death row. But he had been on death row so long, he'd been on death row like 30 years. During that time on death row, he developed severe dementia. He could not understand, could not remember. He couldn't remember the crimes, and he was incapable of understanding why he was in jail. Because to him, he didn't do anything. He had dementia. He didn't understand. And so he was on death row. His time came up. The execution warrant was signed. His lawyers got the case before the Supreme Court. The Supreme Court actually said, you cannot execute him, right? Because he's not competent. If he doesn't recall what happened, if he doesn't understand what's happening or why it's happening, that's cruel and unusual punishment. Or if I just take you into a room and I say, I'm going to put you to death now, and you have no idea why, like, that's really screwed up. So the Supreme Court said, no, you have to be competent. We know that before, the Supreme Court has ruled before people who have developmental disabilities, they can be executed if their IQ is above a certain, I believe it's above 70. Below 70, you cannot execute someone in terms of IQ points. And now we've learned if you have dementia, Alzheimer's, and along those lines, if you can understand what's going on, you can remember, you can be executed. If you can't remember, you don't understand what's going on, you can't be executed. So what basically happens is they just transitioned it to life, because there's no coming back from dementia. It's unfortunate. I'm going through this with my father, the only treatment there is for dementia, the only one that we can treat is Alzheimer's. Every other form of dementia, there is no treatment. Like, it is a horrible, horrible process. And even with Alzheimer's, we can't prevent it, we can't cure it. We can slow it down a little, so instead of taking 2-3 years to progress, maybe you have 5 years left. Like, again, it's not a great situation. Last night I was actually staying up with a man who has Parkinson's disease and has severe dementia, to the point where he thought that I was there holding him and forcing him like he was in prison. Like, he threw punches at me, kicked me. He actually even beat on me. Like, that was not fun. And the thing is you can't get mad because you're like, that guy thinks that you're torturing him. Like, I mean, I do the same thing in that situation. I try to escape. So it's an interesting process. But again, should not be confused with insanity, which is the defense. Now, if you plead the defense of insanity, like we discussed before, and you get found not guilty by reason of insanity, as we discussed before, you do not go home. You go to a prison hospital until the doctors of that hospital say that you are no longer a threat to yourself or to others. So a crime might only have a 5-year prison sentence, but if you plead insanity, you might spend the rest of your life in a prison hospital. Right? Those sentences are indefinite. And they are technically civil actions, they're not criminal actions. Because you're not guilty, but then we're dealing with the civil aspect. So we're talking about the test for insanity. And I asked you before to think about what does it mean to be insane? Okay? How do you define insanity? How do you define if somebody's insane? Unfortunately, we use the term insane a lot, again, and usually in a derogatory manner, which I'm guilty of myself, but is definitely highly offensive and not respectful of people who legitimately have severe mental illnesses. Right? Well, we might say, oh, like I say it all the time, like, my ex is insane. Like, is she really? No, she's just a dick. But it depends on how you define insanity. Right? Are people who are schizophrenic, right? They hear voices and they see things. Are they insane? Does it depend on the level of schizophrenia? Right? So I've dealt with people who are schizophrenic who they see, with the last one that dealt with, saw spiders. No spiders were anywhere, but just saw spiders. Like not tons, but just here and there would just see spiders. And you could not say those spiders, there's nothing there because this person sees them, right? That's their reality. So all you do is just tell them that they're safe and that, you know, you're there to help them and protect them, etc. But on the other end of the spectrum, you have people like the Son of Sam. Right? Son of Sam was the famous serial killer in New York City who got instructions to murder people from his dog. Both technically have an underlying schizophrenia. Are they both insane? Is either one insane? It's a hard question to answer. And it's part of the reason that there are numerous tests for insanity depending on the state that you're in. Right, so we're going to begin with the Monotony rule. The Monotony rule is a very, very large rule, very, very comprehensive. It used to be the prevailing rule, and it still is to a certain degree. But the Monotony rule comes from a case called not go figure. It was an insanity case. And this is the right-wrong test. Right? So remember, if it's the affirmative defense, the defense has to put on evidence. They have to show their defense by a preponderance of the evidence. So they have to show this person was insane by a preponderance of the evidence. In this case, the Monotony rule, the right-wrong test, the defense has to show that, one, the defendant suffered a defect of reason caused by a disease of the mind, and this is language from the case, and two, consequently, at the time, he, and again, this applies to anyone who uses the term he, did not know that A, the nature or the quality of the act, or B, that the act was wrong. If you read Myers versus State of Indiana, this gives you a pretty good indication. This is a very interesting test, and it's a very hard one to meet. For people who are even just, legitimately, they are constantly talking to the wall, they're running into it, they're hurting themselves, they have no control of their actions. It's even hard for them to meet the standard, right? Because the standard says you have to suffer from a defect of reason, right? So you cannot you're not fully rational, right? That's all defect of reason is. You're not fully rational, and you're not fully rational because of some disease of the mind. Disease is a term that's thrown around quite a bit. And in the law, usually means there's some problem, some issue with the mind. Now, this is very broad, right? A disease of the mind could be everything from depression, anxiety, agoraphobia, OCD, to schizophrenia, to borderline personality disorder. I mean, you're talking a large gamut. So the first one, you can probably get most even sane people qualified for. The second one is the problem, right? So basically at the time, because of your lack of being able to reason, you did not know about the nature or quality of your act, right? So let's say you think that you have a chainsaw and you're chopping down a tree, or you're cutting down a tree. That's what you think is happening. In reality, you're murdering somebody, right? You're taking that chainsaw and cutting them in half, whatever it is. Your reality is you didn't understand what you were doing, right? Like you had no clue what you were doing. You thought you were chopping down a tree. You didn't think that you were murdering somebody with a chainsaw, an axe, whatever, right? You didn't understand the nature or the quality of your act. And here's the big kicker. This is or. This is not an and, it's an or. Let's say that you did understand what you were doing. Like, I am killing this person. If you did not know, because of your mental disease or defect, your lack of reason, that the act was wrong, then you met the test for insanity. Right? So you might think, I'm killing this person, but I don't know what's right and what's wrong. Now, this is the hard one to prove. The nature quality of the act, I mean, we can tell somebody's having a schizophrenic episode, like that's obvious, right? They're going to get insanity very easily because not understand the nature quality of the act. But the right wrong test is pretty hard. So think about people who are sociopaths. So I read one statistic which just it blew my mind. Approximately 20% of the United States population are sociopaths. And that doesn't mean they're violent people. Most sociopaths, in fact, aren't violent. Basically, what qualifies you to be a sociopath is you lack empathy, you lack the ability to feel. Like, you don't understand what feelings are. You don't have those. You don't have feelings. So you lack empathy for others and their feelings. Most times, and this is true for people who like suffer from depression or whatever, they engage in a process called masking, right? Where a sociopath who legitimately does not understand feelings, like they don't understand laughter, they don't understand fun, they don't understand sadness, they can't feel it. They have no feelings. They are just literally existing. What they'll do is they'll read the room. And they'll do whatever everyone else in the room is doing. Right? So let's say it's a funeral, and the sociopath, they don't cry, they don't feel sad, they don't have it. Like, they literally cannot because of a problem with their brain. But they will end up crying. They will end up doing whatever everyone else in that room is doing. Right? Just so that it looks like they're fitting in, that they're not standing out. Now, you do have sociopaths that take things too far, and they go to the wrong. Right? They do bad acts. Well, just because you can't feel doesn't mean you can't tell the difference between right and wrong. Right? Yeah, you might not be able to feel sadness, you might not be able to feel regret or remorse, anything along those lines, but you know that murder is wrong. Right? So insanity, the or, B, is really hard to prove. Like, you couldn't know what you were doing was wrong. There's a case where, and I don't think they used to not know this case, but there's a case where a woman, and this was actually, I think it was in Missouri, so it was real famous when I was there. This actually has happened a couple times across the country. But a woman was a stay-at-home mom, and she had like 2 or 3 kids, and they lived on a pretty big lot. I mean, several acres and a pond and stuff in it. This Missouri, like, land is crazy cheap. And her husband was at work, and she suffered a mental break. And what she believed is that God told her that in order for her children to be cleansed, in order for them to remove the demons from them, she had to drown them. So she took her kids out to the pond, one by one, and drowned them. Husband comes home, obviously freaks the hell out, calls the police, and then gets arrested and goes through that process. In this case, this person definitely suffered a mental defect, right? They're hearing no voice. People who say, like, and this is actually, it's legally, it's interesting, and it's also interesting from a religious perspective. When people say they talk to God or they hear God's voice or something along those lines, they may be having a religious experience, or they may actually be having mental disease. Not to say all religion is mental disease or something along those lines, but if you're hearing a voice, maybe it is divine, who knows? But chances are, if you're hearing a voice of something that's not there, then yeah, you have some kind of schizophrenia. Now, in this case, right, she definitely had a defect of reason by the mind. At the time, she knew the nature and the quality of her act. She knew she was drowning her children. Right? She knew she was ending their lives. But what she couldn't know, what she didn't know, what she couldn't appreciate was that drowning her children was wrong. Right? Because if God tells you to do something and tells you that's the right thing to do, then you think you're doing the right thing. You can't tell what's right and what's wrong because that voice in your head, that you think it's God, maybe it is, maybe it isn't, but that voice in your head telling you to do something, the traditional norms of right and wrong no longer apply. All right, so ultimately she was found not guilty by reason of insanity. And she went to a prison hospital and she's still there, if I recall correctly, because she met this part of the test that she could not tell the difference between right and wrong, right? God, if you believe God's talking to you, God tells you to do something, and you're even the slightest bit religious, you're probably going to do what your God tells you to do, right? Like, that's a big deal. So that's where this comes into play. If we look at other states, some states that involve the irresistible impulse test, right? So this is a fun one. Basically, we say, okay, you have to have mental disease, or we call it mental disease defect, but you have to have some kind of mental disease, which caused the defendant to lose the power to choose between right and wrong. So what we're saying here is they know the difference between right and wrong. So unlike Monotone, here they know there's the difference between right and wrong. But their mental disease took away their ability to choose the right and the wrong. All right? And it took away their ability to avoid the alleged act. All right? So basically, they knew the difference between right and wrong, but they could not make the good choice to do right because their free will was destroyed by the disease. You also have to prove that the mental disease was the sole cause of the act. So if there's some other reason that you did it, some other motivation as well as the mental disease, you're not going to qualify for the irresistible impulse test. If it is just the disease, then yeah, you qualify. So I like to think of it this way. Think about people who suffer from kleptomania. Kleptomaniac is somebody who cannot stop stealing. Right, like that's, they go to a store and they shoplift. They might have the money to pay for it. They usually do. Have the money to pay for whatever it is. But they steal. They shoplift. Kleptomaniacs. There was a celebrity who got busted a while ago for stealing, for shoplifting. Right, and she's a multi-millionaire, and she had like $10,000 in her pocket, and she just didn't pay for it. Here we can argue insanity, right? Because if you have kleptomania, something is wrong with your brain. You know that stealing is wrong. If you're a kleptomaniac, you know what you're doing is wrong, but you have no control over it, right? You steal because the disease makes you steal. You don't have the control. You don't have the ability to say, no, I can't do this, because that rationality has been taken away from you. Your free will has been taken away. There's always a really interesting one, which is, what if you are, let's say you're poor, right? You are walking in a crowded area in New York City, or maybe you're on the subway, and the guy in front of you, his wallet is barely in his pants. It is hanging way out. You've never stolen anything in your life, but you grabbed the wallet. Is that an irresistible impulse? Because you know what you're doing is wrong, but you just couldn't help yourself. Right? Like this guy was a prime target, whatever, like you just could not help yourself. So you've lost the free will. Now the problem here is you were poor. So maybe the money is also motivation. Maybe you did have mental disease, but if the money also comes into play, this defense does not work. We have another major rule, which is the product test. This is the Durham rule. Durham says that, and this is great, like this is the easiest test. The defense has to prove that the criminal act was the product of a mental disease or defect. Like that's it. That's literally just, that's it. All you have to be like is like, yeah, this person committed the crime because their mental state. Here. Okay, that's not for insanity if we're following the Durham rule. I can't think off the top of my head of really any states that follow the Durham rule, just because it is so forgiving. Right, so like when we do surveys of people don't like the insanity defense. There are states that are trying to eliminate the insanity defense. Because people have this misconception of what it is. Right? They think that you just go in, you act a little crazy, and then you go home. They don't understand that it rarely gets pled. If it does get pled, you get put into a hospital for a long time. And they put pressure on state legislatures. The state legislatures are trying to, I think Texas is one of them, a couple other states are trying to abolish, maybe Mississippi, are trying to abolish the insanity defense, which that is not really abused as much as we think it is, but it's definitely needed for justice to, I believe, for justice to be served. Right? I mean, if you can't control what you're doing, then you belong in a hospital, not a prison. But that's just my take. Then we have the substantial capacity test. This is the model penal code test, the MPC test. Right? So remember we talked about the model penal code, groups of scholars get together, they decide what the law in a perfect world would be, and then states will largely adopt what they say. So there's some uniformity there. But under substantial capacity, you have to prove two major elements and then two sub-elements, or one sub-element, I should say. So you first have to prove that as a result of the mental disease or defect, right? So this act was the result of a mental disease or defect, which again is legal terminology, includes everything from severe mental illness to developmental disabilities, you name it, right? So disease or defect. Prove that first. Then you have to prove that the defendant either lacked the substantial capacity to either, one, appreciate the criminality or the wrongfulness of their conduct, or two, to conform their conduct to the requirements of the law. So this should seem very, very, very familiar. Right? It definitely has a feel of the test we just talked about a couple minutes ago. Right? And we think about the lady who drowned her children. Obviously, we have to have mental disease or defect going on. At the time, the person lacked the ability, substantial capacity, maybe they had some capacity, we're talking substantial capacity, to appreciate the wrongfulness of their actions. I guess God told them to do it and it was the right thing. Or the person lacks substantial capacity to conform their conduct to the requirements of the law. Right? So, one example I'll give is another person I had worked with. He was in his late 70s. Definitely had dementia. So we had the mental disease defect. And what he was notorious for is when he was not in a hospital, well, when he was in the hospital, he did it too. But when he was released by the hospital or released by the police after he commits his crime, he would just go back and do the same thing. So we had this one guy who would stand on the side of a major road, pull down his pants, and just masturbate. Just standing on the side of the road, right down the sidewalk, in plain view of the stoplight, and would just masturbate. Which he was in his late 70s, and he could still do that. So, like, I mean, props to him. Like, that, okay. Like, good for you, bud. But the problem is obviously we have a mental disease defect. He knew what he was doing was wrong. Right? I mean, he knew what he was doing was wrong. He always smiled, like when he was arrested or when he gets brought to the hospital, he smiles. He's a pleasant fellow. He just has this really weird proclivity. But he lacks, and he's never been actually fully charged because he lacks the substantial capacity to conform his actions to the law. Right? The law says you cannot masturbate in public. He does not have the ability to do that because of his mental disease or defect. Right? So he knows it's wrong, but it's just his thing. Right? So one thing that when you deal with older patients or when you deal with people who have dementia, routine is key for them. Right? You have to keep a routine. It's soothing. They know what's happening. It's easier for them to remember, whatever. So for him, his routine involved masturbating on the side of the road. He could not change that. Right? The only way to change it was to keep him in the hospital or keep him in jail, and he still just masturbated in the hallways and things like that. So I mean, like, he was, I mean, good for him, but at the same time, that's really sad. You can't control your actions, right? You can't make them conform to the law. So the substantial capacity test really does mimic the Monod rule, right? The right-wrong test. So they're very similar, but they do have, like I said, those key differences. So if we move on to diminished capacity and age, this is also part of the reason I hate children, and we're going to talk about why. All right, so diminished capacity is actually it's not an affirmative defense. Right? It is a failure-proof defense. Basically, what happens here is the defendant attempts to prove or to show that the prosecution did not prove that he was capable, or they're trying to prove that he's incapable of the requisite intent. So if we remember, we talked about mens rea, we talked about intent is purposefully or knowingly, but there's also recklessly and negligently. And we say this guy has diminished capacity in the sense of maybe they are not fully developmentally disabled, like ever seen the movie Forrest Gump? We're talking like, let's say they're like Forrest Gump, right? Where you not have we don't have a full disability, where you don't have like full Down syndrome or autism or something like that. But there's definitely something going on upstairs, which makes your capacity lower, right? To understand things, to act in certain ways. That's where diminished capacity comes into play. And we say, okay, this person could not have premeditated the murder. Or this person goes to the bathroom in their own pants. Like they have to wear a diaper, they have to do this. Like they have to have a nurse come in, they have to have people shop for them, et cetera, et cetera, et cetera. And yes, let's say they did commit the murder, but we're going to say they didn't have the ability to premeditate that murder. Right, so murder in the first degree, which is usually premeditation, it's not going to apply, right? Instead, the defense might argue, oh no, it was reckless, right? She knew what she was doing was wrong, but she just did it anyway. She didn't premeditate it. It just happened. That's diminished capacity, right? If it's not first degree murder, because the person couldn't purposely do it or knowingly do it, but maybe we have a manslaughter or a second degree murder or something along those lines. All right, so when you do diminished capacity defense, basically you're saying, yeah, we committed the crime, sure, it's not technically an affirmative defense, but you're saying the charge of first degree murder is not what I should be charged with. And what happens is juries can include and decide to punish on what's called lesser and included charges. All right, so if I charge you with first degree murder by premeditation, under the statute, I'm also technically charging you with second degree murder, manslaughter 1, and manslaughter 2. All right, so I'm charging you actually with 4 things. We call it a murder trial because we're focused on murder. But what it allows the jury to do is say, okay, this person is not guilty on this idea of premeditation, first degree, but they did know what they were doing was wrong, so let's look at manslaughter. And they'll come back and they might find the defendant guilty of manslaughter as opposed to of murder. We also have diminished responsibility. So this is an excuse defense in which the defendant attempts to prove that what he did was wrong, but under the circumstances, he is less culpable or responsible. Right? So again, here the defendant is seeking to be punished on a lesser and included offense. Right? So you're like, yeah, I did it, it was wrong, but I'm not as responsible as somebody who like sits down and really premeditates something. You know, that it was just I was angry. It was a heat of passion. This is this comes into play if you find your significant other in bed with somebody else, right? You go over to the nightstand, grab your gun, and shoot them. You're going to be arguing diminished responsibility. Right? You're going to say if they charge you with first degree murder, you say I didn't premeditate that. Right? I didn't know what was going on. That's why I went into shock. I don't know. So we're going to look at charging you or punishing you for a lesser charge. Now, one that's a lot easier to remember is excuse defenses. Excuse defenses are fun because we have certain thresholds under the law. So in the United States, under the common law, if you are a child who is 7 years of age, or excuse me, under 7 years of age, you have absolutely no criminal capacity. So let's say a 6-year-old brings a gun to a school and starts murdering his classmates. That 6-year-old, under the common law, cannot be charged with a crime. Not a single crime. Because that 6-year-old, we presume, and then we say, has no criminal capacity. Right? know much about kids and development, and I don't care, but I assume at 6, like you can talk and shit at 6, right? Yeah. So like you can talk and stuff. Like I'm sure you can hold a gun. But yeah, anything under 6 you can be held criminally responsible for, or cannot be held criminally responsible for. However, you can be held responsible in civil court. Right, so there's a famous case that we read at some point during the term in one of the classes, in which basically there was this little kid. They were having neighbors over for a barbecue, and the lady was going to sit down in the chair, and the little kid thought it was funny and pulled the chair out from under her. Right, so she falls on and on. Problem is, she shatters her head. Now, is there a criminal act here? Yes, and when we look at assault and battery, we're going to see that there's a criminal act. But he was under the age of 7, could not be charged. However, in civil court, even if you're a baby, we can sue you. Now, obviously, your parents are going to be the ones who pay the damages. But yeah, if you're a baby and like, oh, let's say like you're a very strong baby, and for whatever fucking reason I've never held a baby. Like I would never do that. It's fucking gross. But like, let's say that like I was fucking holding a baby and it punched me in the face. Assuming I didn't punch it back, like I'm going to sue it because fuck kids. Yeah, so civil cases, we can sue anyone. Criminal cases, under 7, no criminal capacity. Then we have an interesting range. We have 7 to 14. So between 7 and 14, children are presumed to have no criminal capacity. We presume that they have no criminal capacity. But this is a rebuttable presumption. Right, so what that means is the prosecutor can say, oh, no. They absolutely had capacity. And what they might bring in is grades, they might bring in socialization, they might bring in your number of friends, they'll bring in your hobbies and activities. They're going to show all this to the judge, and like, judge, this person, this child absolutely had the ability to understand what they were doing and understand that it was wrong. Right? Otherwise, I mean, we can have 13-year-olds going into a school, and definitely a 13 or a 14-year-old can use a gun on their classmates, and they have before, right? Initially, under the common law, not necessarily statutory law, but under the common law, we say that, okay, we don't think you have any criminal capacity. It's up to the prosecutor to be like, no, and we might even do brain scans. Like we can do CT scans and say like, okay, this person had this issue or whatnot. Or their brain is developed further than it normally is, or they have more responsibility than a person of that normal age range. So again, the prosecutor can rebut that issue. Now, if you are over the age of 14, you have the same capacity, criminal capacity, as someone who is an adult. Right? So basically at 14, we presume you to have the capacity as an adult, even though you might still be in the juvenile court, we say that you still have the capacity as an adult, and you should be held responsible to the fullest extent of the law that we can. Right? If you're 7 to 14, we're saying we don't think you have criminal capacity. Maybe you have diminished capacity, so you did it, but you're not really as guilty. Right? It's this kind of this idea of this moral blameworthiness, of taking responsibility, that sort of thing. Now I'll say this: what's interesting, and it's odd. Some countries follow this. Iran does follow this, but under the Sharia law, weirdly enough, Sharia law basically says you cannot commit a crime. You do not have the capacity to commit a crime until you reach puberty. So we judge that, generally speaking, by, for girls, it's easier. So the first time they have a menstruation cycle, they are considered eligible to have full criminal capacity, right? There's no like, oh, they're still young. No, they're an adult. For boys, it's a little bit more difficult. Usually we're looking at like sexual arousal, sexual interests, that sort of thing, like when they make that switch. We're looking for pubic hair, things along those lines. What's really unfair is, generally speaking, women hit puberty, and girls hit puberty much earlier than boys do. So under Sharia law, and weirdly enough, social science data is suggesting that girls and even boys are hitting puberty at earlier and earlier ages. Right, so it used to be like 12 to 13, and now some people are hitting puberty at like 6 or 7, which is just, wow. A lot of it has to do with what we eat, the hormones, all that stuff. But it is getting moved up further and further. So under the Sharia law, theoretically, a 7-year-old, as long as they've had their first menstruation cycle, if they're female, they can't commit a crime and they can be held fully responsible as adults. Whereas it might take until a boy is 13 or 14 for them to be held responsible as an adult. So it's not necessarily a fair system, but really neither is ours. So it's hard to judge. But the idea here, and the question to ask yourself is, all right, when do we say a kid knows the difference between right and wrong, knows what they were doing, and has control of their actions? Right? And then we have diminished capacity, diminished responsibility, etc. coming into play. So we also have 2 great defenses. I really like the second one, but the first one is duress, right? So duress is an interesting defense, because what you're doing is the defendant is trying to get their actions, which they know are wrong and they admit are wrong, excused by claiming they were forced to commit a crime. Right? So this requires the consideration, not necessarily proof, but consideration and strong evidence of 4 elements. First, we have to look at the nature of the threat. Right? So let's say that I tell you, you need to go rob the Shimon Canal Trust Company, that bank, or I'm going to kill your family. I say that to you. So you go rob the bank. You get arrested, and you say, the only reason I did is because I was under duress. Somebody told me I had to, or they were going to kill my family. First thing we're going to look at is the nature of the threat. Did I have a gun to your head when I said this? Did I have a gun to their head when I said this? Did I just say it? Was I in public? Was I joking? Right? What really is the nature of this threat? Was it a legitimate threat? Would a reasonable person believe that this threat was real? Second thing we're going to look at is the immediacy of the threat. Right? So if I say, you need to go rob the bank, or else in 6 weeks, I'm going to come back and kill your family. And then you go rob the bank, you're not getting duress. Because there's no immediacy there, right? Like, in 6 weeks, you could, I don't know, go to the police. There's an idea, right? There's no immediacy there. But if I am in your home, I have a gun to your spouse's head, and I say, you better go rob that bank. If you don't come back in the next hour and a half, I'm going to blow your spouse's brains out. Well, that's That's a real threat, and that's an immediate threat, right? Not something that can happen in the future. We also have to look at the level of belief regarding the threat. So maybe it's like a legitimate threat. Maybe let's say your best friend, right, comes over and takes a gun, like, let's say you think it's a real gun, maybe it's fake, but they take a gun, they put it to your wife's head, and they say, rob the bank or I'm going to kill her. Okay, well, it's the issue of the threat. It might seem real because it looks like there's a real gun. It's immediate because we're not talking about something that could potentially happen in the future. We're talking about something that will happen immediately if something's not done. But we also have to look at the level of belief regarding the threat. So if it's your best friend and you know your best friend like they joke around and they're terrible and they just have really shitty jokes that aren't funny, you don't really believe in the threat, but you go rob the bank just in case, you don't qualify for duress, right? You have to believe fully and completely that if you do not commit the crime, that harm that's being forced upon you will occur. And there is a limitation on the crimes to which this defense applies. So generally speaking, you cannot argue duress in murder cases. Right? So let's say I take your significant other, the person you're dating, and you're in a long-term relationship, you think you're in love and all that bullshit. I take them with a gun to their head, or maybe I take, not even them. I take a gun to your head, and I say, okay, I put a gun in your hand that has one bullet, the safety's off, it's cocked, and I say, if you do not pull this trigger and shoot your significant other, your spouse, whomever it is, you do not kill them, I'm going to kill you. All right, here, do we have a nature of the threat? That's fucking severe. Is it an immediate threat? Absolutely. Do you believe it? Yeah, those circumstances? Absolutely. But let's say you pull the trigger and you kill your spouse. And then the gunman who has the gun to your head makes good on his promise and puts his gun away and just walks off. Right? It just disappears into the night. And we'll have videotape showing that, there was literally a gun to your head. Right? So there's no question. There's literally a gun to your head. You cannot argue duress. Duress does not apply to murder. In that situation, under those circumstances, as odd as it seems, under the law, you have to die. Right? If it's you or your family, they have to die, not the other person. So if it's something like bank robbery, something like that, we say, okay, we can apply duress. Rape, we don't usually apply duress. Murder, we don't apply duress, but we should. Rape, I'm on the fence about. So that's a tough one. But murder, I think you should be able to say hey, the person literally had a gun to my head. It's either me or some other person. All right? You can't say that you're acting in self-defense because the other person doesn't do anything to you. It's this third party. So you do lose the ability to claim defense of duress, but you may be able to claim diminished capacity, diminished responsibility, things along those lines. And honestly, realistically, if somebody has a gun to your head and we have it on camera saying you have to kill this other person or I'm going to kill you, no prosecutor in their right mind is going to bring that charge. No prosecutor is going to charge you. Because think about the opposite of that. Keep in mind, most prosecutors are elected. So think about that. If it gets out in the news that this man This poor man had to kill the love of his life because there was another man who literally had a gun to his head. And now you're going to charge the poor man who lost his wife or his spouse or whoever? You're not getting reelected, and you're going to get universal friggin' hate. Like, that's not going to end well. So again, prosecutors, they wouldn't bring it, but if they did, theoretically, you would not qualify for duress. Then we have a fun one because, like, so it's the defense of intoxication. We all do things when we're fucked up. Like, I feel like it's a fair thing to say. Like, we all do things that we wouldn't normally do. We do stupid shit when we're fucked up. Right? Like, I was in college, I know I did a lot of stupid shit when I was fucked up. I woke up on the fraternity roof naked a couple of times. Don't know how that happened. And I have a fear of heights, so that's even weirder. But we do dumb stuff, right? We do have a defense of intoxication. This only applies to involuntary intoxication. Right, so if you get drunk and then you pick up a gun and you're just like, you are so hammered, you're just kind of like in and out of it, and you pick up a gun and you just, bam, shoot somebody who's sitting on your couch. We're not giving you the intoxication defense. You're the one who chose to get drunk. You're the one who chose to drink too much. You're the one who chose to get drunk. You're the one who knows your body. You're the one who knows how you act when you do get intoxicated, right? Generally speaking, we all know how we act when we get intoxicated if we drink. And like, I'm a really, really fun drunk. I have a really good time. There are people who are, when they get drunk, they are horrible human beings. I mean, they are like borderline evil. I mean, they will fight, they whatever, right? So the idea here is, you know how you act, you had control, you decided to get drunk knowing what you were going to do. Screw you, you don't just get to go home. However, let's say you're at a party and you're I was always the designated drunk driver, but let's say you're the designated sober driver. And you're at this party and you're having fun. You do something dumb, which you should never do at a party, is you set your drink down. Let's say you're drinking, I don't know, fruit punch or something. You're not drinking alcohol, but you're just drinking like fruit punch. Well, you set your drink down on the table so you can go to the bathroom. You come back and you finish your drink. Unbeknownst to you, while you were in the bathroom, somebody spiked your drink with Rohypnol, right? Roofies. Which quite literally makes you black out. During your blackout, maybe you get into a car crash and kill someone, right? Because you're intoxicated technically. Maybe during your blackout, you find a gun, you pull the trigger, you don't know what's happened, right? Here, we will allow you to claim intoxication because it's involuntary. You were purposely not engaging in drinking. You wanted to be safe. You didn't want any of these bad things to happen. But somebody, unbeknownst to you, forced you, right, to take intoxicants. So if somebody forces you, then we're going to say, look, you're not to blame. Yes, you did it, but you're not the one who chose to get drunk. You're not the one who chose to get intoxicated. You didn't do these things that the person who did choose did, right? I mean, there's a huge difference in moral culpability between the two. That being said, voluntary intoxication. So saying to a judge, I was drunk. may be relevant still and may get you a lower sentence, but it will not excuse criminal liability. Right? So you get into a fight and you go to trial and you're like, oh, I was drunk. And like, okay, doesn't matter. You got in a fight, you hit this other guy, jack him up, right? You're charged with assault and battery. You get found guilty. At sentencing, you can say to the judge, honestly, my day-to-day life, I'm very mellow, I'm a pacifist. I drank, and I was drunk when I did it, and I regret that fully. And I honestly believe if it wasn't for the alcohol, this would never have occurred. Well, the judge is going to consider that, right? I mean, like, especially if it's a minor thing. So if we're talking murder, like, you can go fuck off. But if we're talking like something like assault and battery, you got into a bar fight, and you tell the judge I was drunk. But look, here's how I normally act the rest of the day. I have character witnesses who come in, they talk about how I'm a nice guy, I'm always open, I'm non-confrontational. You will probably get a reduced sentence, right? So instead of a year in prison, it might be probation. But there will be a caveat. Usually if you tell the judge you were drunk, they're also going to sentence you to AA. Right? They're going to sentence you to some kind of rehab recovery program or center. Now, we're going to talk about drunk driving later in this course. We're looking at the crimes, but has everyone here consumed alcohol? Has anyone not consumed alcohol? Okay, a couple have consumed alcohol. Okay. The first time that, this is not legal advice, this is for educational purposes, and please don't do this, but the first time that you consume alcohol and you drive right afterwards, generally speaking, it does not qualify for DUI. For everyone else, it does. Right? And the idea is you didn't know what the intoxicants were going to do to your system. I had one beer and it got me drunk and I didn't know about it. Or I took these new pills, right? The doctor prescribed them to me, and it caused me to start swerving all over the road. Technically, I'm driving intoxicated or under the influence. You get that excuse the first time, but if you continue to drive, knowing taking those pills, no, you don't get that excuse. So just know that is there for you. Like, don't do it, but you get one chance at it. Then we have entrapment. Oh, I love entrapment. So basically, entrapment is when government agents get a person to commit a crime that they would not otherwise commit. So think of it this way, and this is my favorite example. I use it a lot. You probably heard it. You're going to hear it again. You have like a 1950s style nuclear family, right? And you're all deeply religious, and you're all just gosh darn nice, right? You don't say curse words like heck, because that's a bad word, right? You're a tight-knit family. Every night, mom cooks this great dinner, and you sit down together at the dinner table. Dad's at the head of the table, mom's at the other head of the table. You're on one side of the table, and your sibling is on the other side of the table. And your dad looks around and says, okay, oh, don't eat yet. We've got to pray. And so you pray. And as you're going to pray, the phone rings. And your brother or your sister, they get up to go grab the phone to answer it for. And your dad says, no. This is family dinner time. Remember, we eat together. We stay together as a family. They can leave a message. We'll call them back. But let's stay together. And brother sits down. The father then looks around the table. He goes, "You two rascals. So cute. I love both of you. Why don't you tell me about your day? Golly, I want to hear about your day. What all did you do? What did you learn today?" Right? And so you all decided to tell them all about what happened to you during the day, what you learned, the friends that you made. And your dad is just so excited. Your mom's excited. This is a great family time, right? We're just loving it. We're having it. We start talking a little bit about religion, and we mix that in, and it's just this what you think of as like perfection, right? And suddenly, at the door, and Dad says, "Oh, Skip, 1 second, hang on. I know we don't normally answer the phone, but if somebody's at the door, maybe somebody needs us, somebody's in trouble or something. I'll just go see quickly who it is, and then I'm going to come back, and I want to hear the rest of your story. I want to hear about that Boy Scout merit badge you earned. I want to know how you did it, because golly gee, I am just gosh darn excited." So your dad gets up, goes to the door. At the door, there's a man. Kind of baggy clothes, it was kind of looks a little dirty. And your father says, "Hi, can I help you?" And the man at the door says, "Hey, I'm gonna buy some meth." And your dad goes, "Oh, golly gee, no. Oh, gee whiz, no. Gosh darn it, no. Because drugs are bad, and we just say no to drugs. Do you want to come in and have some dinner, and we'll talk about that, and we'll talk about your salvation by the Lord and Savior Jesus Christ?" And the drug dealer is like, "What the fuck?" Right? The drug dealer says, "You know why you should buy this meth?" And your dad goes, "No, I just know drugs are bad." And your drug dealer says, "No, drugs actually aren't bad. Meth brings the family closer together. So if you all buy this meth, you take this meth, you are going to bond more as a family. You're going to have better family time. You're going to have better religious experiences. It is just going to be amazing. It's going to take your great life, and it's just going to blow it out of proportion." And your dad goes, "Oh, gee, this sounds amazing. Meth sounds amazing. Yes, 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 yes. I will buy the methamphetamines and I will give it to my children so that we can have a happy, happy night." And so he reaches into his wallet. Your dad pulls out the money, gives it to the drug dealer. Drug dealer puts a handcuff on your dad. Turns out the drug dealer was an undercover police officer who was going door to door trying to sell drugs. That scenario actually really happened. Like the police have tried to go door to door selling drugs before, just to make arrests. But that happened, right? So your dad gets arrested for possession of methamphetamine, or for at least the sale or buy methamphetamines, and it goes to trial. In a trial, your dad is going to claim entrapment. Now, there's a majority test for entrapment and a minority test for entrapment. So the majority of states have adopted what's called the subjective test for entrapment. Under the subjective test, we ask whether the defendant, right, whether the intent to commit the crime originated from the defendant. So did it originate from the defendant, or did it originate from law enforcement, like this intent to commit this crime? So in this case, we do the subjective test. Your dad told the drug dealer no. Your dad didn't solicit the drug dealer. Dad didn't know the drug dealer. The only reason that he was going to buy the drugs is because the drug dealer, who was the cop, talked him into it. So did he have intent to buy drugs up until the point that the cop like basically forced him into it? No. No. So under the subjective test, we're not worried about it. He's going to be excused, right? Was there a criminal act? Yes, there was. Does he know it was wrong? Well, yeah, he even said, "Oh, gee, it's wrong." You just say no. So we don't really have justification, but we do have an excuse, right? We do have an excuse. Now, that being said, this is rebuttable, right? So we say, in this case, like you didn't instigate the transaction, you weren't seeking out the drugs, you weren't doing any of that stuff, right? However, let's say that dad has a little secret. Turns out dad, the reason he's so fucking happy and so loving to his crotch goblins is because he's always on meth. Like when he goes to work, he goes and gets his Dunkin', and then he goes down Fifth Ave and stops at the corner, gets his daily supply of meth to get him through the day. And that is why, golly gee darn it, he is so happy, so gung-ho, and wants everything to be perfect. Your dad's a meth head. Okay, that changes things, right? Because in this case, this transaction, did your dad have the intent? No, absolutely not. But, does your dad have a prior history? Does your dad know what meth does? Does your dad know meth is illegal? Does your dad, did your will get overcome? We can introduce the fact that your dad buys meth every day. Yeah, maybe he wasn't seeking it out here, but he does have a predisposition to committing your crime. Right, so that's our caveat, is a predisposition. So you've committed similar crimes or you've committed the crime in question before, you have a predisposition, and generally speaking, entrapment is not going to work for you under the subjective test. Great case on point is Oliver v. Nevada, 1985 case. Now, a minority of states follow the objective test. Right? So for the objective test for entrapment, the defendant has to prove two things. First, the defendant has to prove that the intent originated with the government. So very much like the subjective test, right? The government is the one that had the intent. The second thing the defense has to prove is that their actions, the government's actions, would tempt an, quote, ordinary, law-abiding person to commit the crime. So if we take away the fact that your dad is a meth head, and you know what to say, like, he's just really fucking annoying. Either one of these, right, he's going to get off. Because the drug dealer did the intent originate with the government? Yep. Did that drug dealer try to find out information and try to make a sale, overcoming their will and basically saying, like, would an ordinary law-abiding person have done the same thing? Well, if somebody tells you it's not bad, it's good for you, it helps your family, it's not illegal, it's whatever, whatever he had to say to sell the drugs, a normal person, a regular person, might very well do the same thing, right? Just an ordinary person would do the same thing. So, from a subjective test, he can absolutely get off. Objective test is going to be a little bit more difficult, but he probably will. And under the objective test, we do not have the predisposition issue. Right? So even if you are a meth head, but the actions and the intent originated from the government, at the police, And what they did would make a ordinary law-abiding citizen, even though you're not a law-abiding citizen, but they would make an ordinary law-abiding citizen commit the crime. Even if you had a predisposition, we're still going to say that's entrapment, and the charges will be dismissed, you'll be found not guilty. Right? So again, entrapment, you can make it as just fluffy as possible, and you can see those little differences. Now, is that really the context we use it in? Not so much. Mainly the context that entrapment is used in, and it gets claimed in, are drug deals, like just regular drug transactions, but they're really claimed in prostitution cases. Right, so when you have an officer who goes undercover as a prostitute, makes the deal, and then says a certain phrase, and then all the police rush in, that sort of thing. The question there is that entrapment? All right, so think about this. And we'll say you're driving down the road, and you're in a new city, and you are lost. And for whatever reason, you don't know how to work the GPS in your car or the GPS in your phone, and maps don't exist anymore, so it's what it is. You slow down and you see some people walking down the sidewalk. So you slow down and you pull over and you say, "Hey, can you tell me how to get back to the highway? I am just so lost." And that person says, "I can do more than that." Well, what do you mean? You want to engage in some fellatio? Only cost you $20. Which is about the going rate. And you're like, okay. And then you hand over the $20 and you get arrested. That's where entrapment comes into play mostly. Right? Because the idea here is, where did the intent originate from? It came from the government. Right? He was just asking directions. But then the question, if we're talking the objective test, is would an ordinary law-abiding person have done the same thing? That's difficult to answer, and probably the answer is probably not. Right? If I'm lost in the city and somebody's like, "Hi, would you like to engage in prostitution?" I'm really like, "No, I would not." Because you don't know what they have, and again, a lot of them are victims of human trafficking. It's just a horrible, horrible thing. People say it's a victimless crime. It's really not. So again, it becomes difficult. But yeah, when we're doing undercover operations, especially if we're arresting Johns and we're posing as prostitutes, or when we're posing as Johns trying to arrest prostitutes, that's where entrapment comes into play. Basically, the other person has to engage the law enforcement officer, not vice versa. That being said, next class we will discuss, finally, crimes. Right? So we've gone through the actus reus, mens rea, attendant circumstances, we've gone through all that, we've gone through the defenses. Now we're going to start breaking down murder. We're going to look at murder, first degree, second degree, manslaughter, first degree, second degree, and then we'll get into other crimes. As always, if you have questions, comments, concerns, please let me know, and I'll be more than happy to answer them.